Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be the City of Los Angeles forcing all residential property owners to register their units. This is clearly another money grab by the city. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. The song, it was With You by Dean Lewis. And for those people who always accuse me of only playing old songs, this song was released in the year 2024. Now, let's go over the ground rules for the show. You know, I always open it with a topic, and then we'll call on the people in the Zoom room if you want to ask questions for this hour-long show. And if you do want to ask questions, please electronically raise your hand. In fact, you can do that right now, so you'll be sure that I will get to you before the show concludes. And if you guys are watching it in YouTube Live, I would appreciate it if you hit the like button and also subscribe to my channel, because it certainly does help me, and I do appreciate that. So what's the topic for today? The topic is the City of Los Angeles is forcing all residential property owners to register their homes. The City of Los Angeles is forcing all residential property owners to register their home. And this is based on an amendment that they just passed regarding the Just Cause Ordinance. And what was the purpose for this amendment to the Just Cause Ordinance, which we'll get into? It was for one purpose only, ladies and gentlemen. This is a true money grab by the officials for the City of Los Angeles. It's a pure money grab. There's absolutely no other justification for why this amendment to the ordinance occurs. Now, let's talk a little bit about history. In 1979, and I was practicing law then, representing landlords, the City of Los Angeles started rent control, the Rent Stabilization Ordinance. Now, almost all economists agree that the institution of rent control has one thing that happens, and that is that rents get raised. Yes, rents get raised. And that is because when you institute rent control, you have a limited supply, and it's basic economics, supply and demand. Limited supply, prices are going to go higher. It also creates an atmosphere where investors don't want to build units in a place that has rent control or could have rent control. So by instituting rent control, it has the absolute opposite effect. Now, if you take cities, and this is prior to the advent of statewide rent control, but if you take cities in LA County, Los Angeles County, those that had rent control and those that didn't have rent control, the ones without rent control had more affordable rents. So the politicians are just doing this knowing that it has the absolute effect, but it's trying to curry favor with tenants. Now, if you do start rent control, then the politicians have to also install good cause to evict, that you need cause to evict. You just can't serve a notice to quit on your tenant who's on a month-to-month tenancy. And the reason for that is that if you didn't start the parameter of good cause to evict, then landlords could just circumvent rent control by asking the tenant to move. So every time you have rent control, the statute also has to have a provision that you need specific cause to evict. And hence, that's why the city started this back in 1979. However, the city, under their rent stabilization ordinance for Los Angeles, did have exemptions. Any property built post October 1st, 1978 was not subject to the rent stabilization ordinance. Anything prior to October 1st, 1978 was. However, single-family homes were always exempt from the rent stabilization ordinance for the City of Los Angeles. Now, which means that for those units that were post October 1st, 1978, you didn't need to have good cause to evict because there were no rent control for those units. No reason for that. Well, let's move on to March of 2020, when the nation was struck with the national disaster of COVID. During that period of time, the financial responsibility for this disaster was individually placed on the shoulders of landlords. Landlords could not increase rent for RSO properties for 4 years, ladies and gentlemen. 4 years they could not increase rent. There was no evictions for non-payment of rent or even other violations of the rental agreement. For example, other extra people moving in or pets that were not allowed. You couldn't evict the tenant for non-payment of rent for 4 years, ladies and gentlemen. You couldn't enforce your contract rights. Landlords suffered greatly under the fact that they couldn't raise rents. And even for those tenants who falsely complained that they were suffering from COVID for 4 years, yeah, right. They couldn't even evict the tenant for that. The loss of income to landlords during that period was staggering, ladies and gentlemen. But finally, the politicians were forced to finally end the COVID protection. They couldn't carry on the farce past another 4 years worth of that time. So what did the city do? In the face of all the losses suffered by landlords, and finally they were forced to say, I guess COVID is over, and that was begrudgingly, I might add. They came out with the Just Cause Ordinance. That was instituted on January 27, 2023. And that impacted every unit that was not an RSO unit. Now you're under the Just Cause Ordinance. And that, of course, was including single family residences. It prohibits terminating tenancies without cause and requires relocation assistance for no-fault evictions. So let's pretend, ladies and gentlemen, that you have a single-family home in the city of Los Angeles. Well, based on this statute back in 2023, you're now subject to just cause for eviction. Well, let's pretend you want to sell your property and it's tenant occupied. He's on a month-to-month tenancy. If he wants to move, he's just got to serve you a notice to quit. But I want to sell my house. Obviously, I got to get the tenant out. I've got to stage it. I've got to have showings. The tenants can't be there. No one's going to want to buy a house if a tenant's in possession. But under the Just Cause Ordinance, that's not a reason to evict that you're selling. I know you can't believe this, but that's not a reason to evict under the Just Cause Ordinance. So what are some of the examples under the Just Cause Ordinance? Well, for example, if you aren't paying rent or there's a violation of the rental agreement, like bringing in extra people or making alterations to the premises, or for example, if the tenant is a nuisance, then you would have good cause to evict under this new Just Cause Ordinance. Also, you are allowed to have a family member move in or your owner occupied to move in. That's considered to be a no-fault eviction. And of course, that requires relocation. Now, if you're not instituting rent control for these units, because you're not, why do you need eviction protection? For what basis? If the landlords could raise the rent to whatever they want, there's no incentive for the landlord, unless the tenant is really bad, to get rid of the tenant. So why institute this? And also we have right now statewide rent control, which basically requires good cause to evict for all those units that are not covered under the rent stabilization ordinance. So what was their reasoning? What did they do this for? And they started in 1973. Well, that was a master plan, ladies and gentlemen. And the master plan was so simple to see. It's a total out and out money grab by the city of Los Angeles to enrich their coffers for no particular reason. Now, the amendment to the Just Cause Ordinance just occurred, and that was January 27, 2025. Residents were getting letters. Our citizens are getting letters, and I'm going to show you what this letter looks like right now, ladies and gentlemen. Let's see if I can get this down here. Okay, here we go. Let me share my screen. And right there. Okay, so this is the letter that so many homeowners and property owners are getting who were properties were built after 1978, October 1st, 1978, or even if you have a single family home. You're getting this letter and you're telling you, hey, you're subject now to the amendment to the Just Cause Ordinance. And what is this amendment going to do? It means that you have to register your units and you have to pay a fee. Well, what's the fee, ladies and gentlemen? $31.05 per unit. $31.05 per unit, unless your unit is exempt. So what is the exemption of these units? Well, the exemption of the units would be if it's owner occupied, then, or it's not leased at all. You know, maybe you have your mother staying there, or you have two homes that you live in, which certainly can be. Then you are not leasing the home, so your home is exempt. Okay. Now, if you are not exempt and you fail to pay this registration fee, the $31.05 per unit, you're going to be assessed a penalty. What's the penalty? 150%, ladies and gentlemen, of the fee that you should have paid. So let's pretend you have a 20-unit apartment building that was built in the year 1990. Now, of course, since 2023, you're subject to the Just Cause Ordinance. Well, now you're going to have to pay a fee. So what's the fee? The total fee is going to be about $620. $620 you're going to have to pay yearly. But what if you miss your payment? In addition to the $620, you're going to have to pay 150%, which is over $900. This is just a true out and out money grab, ladies and gentlemen. Now, if you are not subject, you're one of the exemptions because I don't lease my house. I'm not a housing provider. Well, you still have to go to their website, which we're going to talk about in a minute, and you're going to have to file something called registration exemption application. You have to file a registration exemption application. And if you don't, then you're fined. And since you didn't pay, you're going to have to pay the fine. You're going to have to pay the $31.05 plus the fine, which is $150,000. I mean, excuse me, 150% of the fine. Now, what we have here is that the dues are going to be owed by the end of February of each year. However, this year, you're going to get a statement, and you need that statement in order to register, because on that statement, you're going to have a statement number. So you have to wait for the statement to come, even if you got the letter that I showed. But you are going to have through March and April, actually, April 30th, to pay that registration. You have to go on, once you get that registration statement from the city, then you have to go online and create an account, and either you're going to pay the fee, $31.05 per unit, or you're going to have to file that registration exemption application. So what's the website that you go on? And this will be in the show notes when I edit this show after the broadcast. And the website is housingbill.lacity.org/billing. I'll try it again. housingbill.lacity.org/billing. Now, again, when you get the statement from the city, go online, register the unit either with an exemption or pay the fill. Now, is everybody getting these letters? Because some homeowners are saying, I didn't get the letter at all. I know I got the letter for one of my properties. Well, here's a secret that they don't want to tell you. And that is, they're not sending it out to all the homeowners. But if you own a piece of property, a single family residence, for example, and the address of that property differs from the mailing address as recorded at the county recording office, then they're going to assume that you are renting out this unit. And if that's the homeowners that are getting this letter. So homeowners, if you get this letter, wait for the registration statement, so you'll have the registration number. Then you're going to go to that website, once again, housingbill.lacity.org/billing. Now, why are the city collecting these fees? What's their justification for charging $31.05 per unit for properties that are not subject to rent control, but are only subject to good cause to evict? Well, I'm going to read you their stated purpose. This is their stated purpose, ladies and gentlemen. That is, the JCO fee provides programming services and related expanding tenant protection for tenants citywide, and it is administered by the city. Well, that sure cleared it up, didn't it? Let me read that again. Maybe you guys can put your head around it. The JCO fee provides programming services and related expenses for tenant protection for tenants citywide, and it's administered by the city. This is a big joke, ladies and gentlemen. What they're doing is they're encouraging tenants to file harassment claims against owners, so now they can investigate that. Well, I pulled up a Los Angeles Times article that was written on August 19, 2024. And that article went on to state that within the last 3 years, there have been 13,000 complaints by tenants against landlords for harassment. 13,000, that's kind of a big number. Of those 13,000 complaints investigated by the city attorney's office, it resulted, ladies and gentlemen, in 4 actions, 4 fines being leveled. Out of 13,000, only 4. So you can imagine that nearly 13,000 landlords had to defend themselves from these baseless charges of harassment by tenants who are probably just seeking ways to avoid paying rent. And by the way, ladies and gentlemen, this is all in the city's stated purpose of expanded tenant protection. Tenant protection, like these tenants need it. Make no mistake, ladies and gentlemen, the only reason for this statute is a money grab by the city of Los Angeles. They have had placed so much harm on landlords during this COVID period with these insane tenant protection laws, which are all designed to rob income property owners. We're facing a loss of rent. We have increased costs of labor and supplies and insurance premiums that are going through the roof. We are housing providers. We perform an invaluable service for the community, and yet we're looked at as a different animal from any other industry. I want to say personally, shame on Mayor Bash, shame on the City Council of Los Angeles for creating this money grab that impacts the financial situations of landlords. And that, ladies and gentlemen, is my topic of the day. We're now going to open it up to questions and answers, and we know the rules with regard to that this broadcast is for informational purposes only. It is not a substitute for legal advice. If you do want to raise your hand in the Zoom room, I will call on you. So please do that right now. I do see that there's a few hands already raised. And remember that this broadcast is for general information only. If you do have a question about your specific case in my office, please call the office and we'll take care of that. And last but not least, if you are talking to me, leave your camera on because it makes it more enjoyable for everybody. And with that, we're going to open it up to first caller, whose name is, seems like it's Yvette M. I'm going to ask you to unmute yourself. Yvette M., there you go.
Here.
Hello.
Hi. Okay, I have a question. I know that the new law says that landlords, we can't charge tenants for posting notices.
There's a California law, and I had this in my rental agreement that says, hey, if I've got to serve a 3-day notice to pay rent or quit, and this is a state law, then
Right.
I'm going to charge you an extra $50. I had that in my rental agreement because I didn't like these tenants that would force you to serve a 3-day notice every month. Well, the state of California has now outlawed that in their latest eviction rules, which became instituted as of January 1st of 2025. So
Oh,
you cannot charge a tenant for serving a 3-day notice or if you have to post another notice.
I thought that went into effect in April. It's January?
I thought it was January, it might have been April, but in any event, it's the law right now.
Okay. Um, anyway, I thought it went into effect April 1st, 2025, but I'll look and see. But my question is, I was using the AOA lease and it has that $50 fee in there. And my tenant moved out. So am I able, he never paid the $50 fee and I don't know, gave him 4 or 5 notices to pay. Can I take that out of the security deposit?
No, unless it's considered rent. So if you have something in your contract that says all financial obligations are considered rent, then you can because you are allowed to deduct any rent from the security deposit. But if it's not considered rent, then you'd have to sue separately for that. You can't take it from the security deposit.
Oh, okay. That was my
Thank
question.
you very much.
Thank you.
Appreciate you. We are going to move on to Ellis Stagg. How are you?
I'm doing great.
Hello.
Here we go. Can you hear me now?
Perfectly.
Wonderful. So I have a couple of questions. So first big question I have is that if we already have a business license to rent out our property in the city of Pomona, do we still have to get our home registered?
No, this topic that I was talking about was exclusively for the city of Los Angeles. It doesn't affect any other city. So Pomona, you wouldn't have to register that unit.
Okay, good. Second question. So my parents and I are trying to figure out, we're considering letting one of our family members rent or yeah, come into our home, pay rent. So what exactly would the pros and cons of having family members in the property be?
Well, generally, you're not treating it as a business relationship when you have a family member move into your unit. So it becomes a little bit more sticky. But I mean, families do that. I don't think I ever charged my kid rent, but so I mean, you just have to treat it like a business, and lay down the laws. I'd have them sign a rental agreement. But again, it's family, so it's a whole different story.
Okay. All right, got it. Thank you so much.
All right, thank you. We are moving on to Jim Polina. I'm going to ask you to unmute yourself.
Hi, Dennis. How's it going?
It's fine, thank you.
Well, I'm driving at this point, so I'll be extra careful. I know you're always concerned about that.
Yes,
So, I have a question regarding the idea of an illegal unit.
yes.
So, you've mentioned people have changed the master bedroom into a rental unit and put a little kitchenette in there, just plug in appliances and so forth, refrigerator. And as long as they have a doorway between the master bedroom and the house, like 2 doors and locked from either side, that's legal. Basically, I'm renting to a roommate situation. Do I have that correct?
I think you do. I mean, unless you seal off with a wall, then and made basically a duplex, I don't think there's a problem if there's a door. Even if the door is locked on both sides, I don't think that's a problem. It's not illegal. Okay.
Okay, so what if there was no doorway between the room and the house, but there was an exterior doorway into the master bedroom?
Again,
Uh,
if I can walk through the front door of the unit from the sidewalk and then get to every other spot of the house, then I'm fine.
yeah, I wouldn't want that. I want them to be referred or maintained just in the master bedroom and no other parts of the house.
Now, where are you going, Jim?
Costco.
That's good. Well, I like a loyal listener. Like you're on the way to Costco, but you couldn't miss the show.
No, no way. This is the highlight of my Saturday.
All right. Anyway, thank you very much. Listen, pick up some coffee for me when you're at Costco. And with that, we're going to move on to GV. I'm going to ask you to unmute yourself
Hi, Jay. Can you hear me?
perfectly.
Hi, I have a tenant. I've had to call the plumber twice in 1 year for bathtub. The second time it took about 4 hours to unclog, and we had to break a bunch of pipes because it was so clogged. And we pulled out bags of hair. At what point do you back charge the tenant for stuff like that?
Well, if something is unnatural that's going down the drain, okay, then you can charge it. So, for example, if you saw a kid's toy in the drain, then that would be certainly something that would be the tenant's responsibility. You might, I don't think you can charge the tenant for hair going down a drain, but they have these things that you put into the drain as a practical matter that basically will not allow the hair to clog. I would probably invest some money in one of those strainers or that would kind of prevent the hair from going down because people, hair is going to go down a drain and maybe your tenant's losing their hair. Who the hell knows? But unless it's something unnatural, I don't think you can hold the tenant responsible for that plumbing bill.
Sounds good. And then as far as like what's going on at the federal level, do you see this eventually trickling down to California and LA?
And what level, the federal level, are you
So
referring to?
they're cleaning up like with the government and everything, just getting rid of bureaucracy and the regulations and so on and so forth.
I don't see the federal government helping out individual states because that's in the purview of the states how they administer their laws and rental housing laws, et cetera. I mean, we had a shot that the Supreme Court would outlaw rent control, but they chose not to. I mean, obviously, it's a violation of the contract laws that people should be able to charge what they want. But of course, that's not the way it's going to be, and the Supreme Court declined to rule on that. So, but I don't see any help on the federal level.
Thank you.
All right. We are moving on to Maribel. How are you?
Hi, Dennis.
Hello.
Hi. I have a question. It might be a dumb question, but on a no-brainer, but I'll ask anyway because I want your opinion. I'm contemplating on purchasing a property. The choices are a triplex in Inglewood or a quadruplex in Gardena. Inglewood obviously is under RSO. Gardena is not under RSO, but they have what they call a mediation, which is if I'm going to increase the rent of 5% and above, I'm supposed to give the tenants this booklet that they can appeal or something like that. So my question is, if you were the one buying the property, which would you pick?
Uh,
All things being equal, one RSO, City of Gardena not under RSO.
I would definitely pick Gardena because you want the least intrusive government in your back pocket for the properties that you own. So Gardena would be the place. And are they just doing that for all multi-unit? They can't be doing it for single-family residences, townhouses, or condos because that would fly in the face of Costa-Hawkins. But it's rarely have I seen anybody avail themselves of this mediation to determine whether that's a correct rent or not.
Right. So with that being said, Gardena is not under that $31 per unit kind of thing.
No, once again, my opening topic, ladies and gentlemen, was just for the city of Los Angeles and the ilk that run it.
All right. Thank you, Dennis.
Thank you. Okay. Well, here's a regular Margaret O'Brien. How are you today?
Fine, thank you. I have a follow-up question to the question from last Saturday. We have a duplex in Manhattan Beach, and my son has a house that is full of mold and he has to move out, and I want him to move into this unit. I know I have to give the tenants a 60-day notice and I have to pay 1 month's rent, but I don't know how long my son will need this place. Is there a time that
Yeah, I think, first of all, what city is the property located in?
Manhattan Beach?
Okay, so I think you have to stay at least 1 year under the statute. So he's going to have to be there for 1 year, or it could be considered a wrongful eviction and somebody can come back and sue him. So if he's not planning on staying there for 1 year, I would not do that.
Okay. Uh, or can we do it more broadly and just say the whole family, we need this place?
Well, you can, but somebody's got to be there for the whole year. So you can do it, your son, your grandchildren, etc.
Yeah, we do have grandchildren that may want to live there.
Yeah, well, then put them all on the list.
Oh, I could put my whole family, including myself.
Well, I mean, but you're not planning on moving in. Technically, it's the person who's moving in whose names is supposed to be given to the current tenant as to the reason why you want them to move. But if your son is moving in with his children, that would be fine. And then if the son moves out, but the children are still there, I don't see a problem with that.
Okay, thank you.
Thank you. Okay. Harold Rhodes, you got a good question for me today, sir?
Yeah, I got a different one.
Good.
What if owner occupied city of LA, just cause ordinance, if I give the tenant 2 months to move out, after the 2 months he refuses to move, am I still stuck with that threshold of having to wait 2 more months for eviction?
No, there is no threshold per se for that. If you have the right to serve a 60-day notice at the end of the 60 days, if he's still there, then you have the right to just immediately bring forth an eviction.
And then if I bring forward eviction as far as actual time to get in front of a judge and all that, what's the
Well, yeah,
time?
the
Reality.
time period is usually it takes a month to get a judgment, and then we got to wait 2 months for the sheriff to do the lockout.
So is this more like a 4-month project, worst case scenario?
Yeah, I would say so.
Okay.
Now, Harold, I
Yeah,
have to ask you a question now.
yeah,
Are you ready?
I'm ready.
Okay. Are you going to wish me good luck tonight?
Are you going to the Lakers?
No, I'm not going. They're playing in Boston, but I'm praying that they win tonight. Okay.
Oh, 100%. We got the team now. We've got the team.
We've got the team. As you can
We've
see,
got the
my
team.
little Kobe statue's over my left shoulder there.
Hey, if anybody flakes out on you, take me to the game. I want to.
Okay, well, it's in Boston, so we'd have to jump on a plane real quick. We'd have a better chance with Janice since she's in New York.
Oh yeah.
All right, we'll get to you next in an extra person, Janice. But all right, thank you, Harold. We are moving on to Peter. How are you?
Hi, let me get my video going.
There you go.
Can you see me?
Perfectly.
Oh, I do not see myself on the screen. Okay. Hi, this is my first time joining, so I'm really glad you're doing this. This is really great. Thank you for hosting. I got a couple of questions. I have a tenant who was in my property for a little over 13 years, and she notified us that she's going to be leaving at the end of February, which she did on her own accord. I did not evict her. She just decided to leave, which was fine. After she left, we did the walkthrough, and at the time of the walkthrough, she asked myself and my wife for receipts for payment going back 13 years. So,
Receipts of what, please?
receipts of rent payment. My apologies, that she paid rent.
Mm-hmm.
So, we went ahead and took a look at the law, California Civil Code 1499, that specifically states a landlord is obligated to provide a receipt to the tenant for the rent payment should the tenant ask for it at the time of the payment. Now, the question we have is the law is rather ambiguous. It doesn't specify how long after the time period is
Yes,
passed.
certainly not for 14 years. And you never issued receipts, I presume.
No, she never asked.
She paid by a check.
She paid by cash because she's family.
Okay, so then well, I'd get a new family at that point if she's making these demands. But notwithstanding that, give her one sheet of paper that says that you paid me every single month from this date to this date. That's your receipt.
So I don't have to itemize every single
Oh,
month.
say you paid me X amount of dollars. I don't know if you had rent raises,
I
but
did.
did you?
Yeah, we raised the rent over the course of 13 years. Absolutely. I mean, cost of
Right.
living.
So maybe you can say from this date to this date, you paid X amount per month. From this date to the following date, you paid this amount of rent. I just give her on one sheet of paper.
Can I make it even simpler and say this letter is to confirm that you did in fact pay your monthly obligations uninterrupted for continuous tenancy during the 13 years without being
Well,
so
I don't think
specific?
that's a receipt for payment because you're not stating what the rent is.
Okay. Okay.
So,
So we got to be specific to the amounts and whatnot. Okay, I can go through
and
the
by the way,
different.
what family member is this that's demanding receipts?
This is my wife's brother's wife's first cousin.
Oh, okay. Well, that's not much.
Yeah, exactly. It's
It's
not
not a
much.
close family member.
No, no. Okay. Okay, so we can do that. The other thing I wanted to tell you is yesterday I actually sent you an email. We had contacted your office and spoken to, I believe the gentleman's name was Carl. And he said that there was a particular service that was available from your office with regards to providing a letter for us on your letterhead. So I sent you an email yesterday.
All
If
right. Well, we don't talk about specific cases, but of course, my firm does write letters for landlords. Uh,
Okay.
and so we'll get to that letter and we'll give you a call. Hopefully, you put your phone number in the email.
I did, and yeah. Okay, so I just wanted to bring that to your attention so you see it. The last question I have for you, and I'll keep this very simple, is one of the things that I was reading is that if the tenant does not surrender the keys after they leave, that they could claim that they're still in possession. But one of the other things I read was as long as the tenant has put it in writing that they're leaving, which we have that in text, saying that she's leaving at the end of February, we have a photo from the neighbor across the street that she had gentlemen movers at her house moving. When we went to do the walkthrough, she showed up. And second, the property was completely empty. She turned off all the utilities. Nothing was in her name
I think it's
anymore.
overkill, my friend. You don't have to get the keys to declare that the premises have been vacated. The keys are one way of knowing when they
Okay.
hand you the keys, but the fact that they never hand you the keys, but the place is vacant and the
Okay.
utilities are off, you got enough, my friend.
That's what I figured. I wanted that reassurance. Okay, perfect. All right, those were my questions. This is great. And you do this every Saturday, yes, at 3 o'clock?
Every Saturday at 3 p.m. And then if you go to my channel, the YouTube channel at evict123, you can actually see the edited versions of this because I put up a lot of cute pictures and stuff.
Okay, perfect. Thank you. I appreciate it.
Take care.
You
Okay, now we are going to New York. I'm going to ask Janice to unmute herself.
Hi, Dennis. How are you?
I am fine, thank you.
I don't think you want to come to Boston or New York. It's 30 degrees. Uh,
You know, that was on our list because, we do one road trip a year where we go on road with the Lakers. And I don't know, my son wanted to go to Boston and we chickened out and we went to Sacramento and we saw them win there. But if I had known what was going to go on with Luca coming onto the team, I definitely would have made that trek to Boston. But then if I did, I wouldn't have been able to do the show today. So anyway, what's your question, Janice?
to follow up from last week, Dennis, if you have a 6-month lease that's expiring and the tenants don't sign a renewal for 6 months or whatever, and you wanted to add addenda to that original lease, what do you do if they won't sign? Because last week you said they would operate under the previous lease.
Okay, so you have a lease that's expiring in 6 months, so let's pretend the end of March, okay? And what are you trying to do? Do you want to renew the lease?
Yeah, because it's a property manager's lease that I no longer use and I don't like it.
Okay, and what city?
Roseville in Placer County.
Okay, so you can just give them a new rental agreement and make them sign it if they don't. And this is a single family residence, right?
Right.
If they don't want to sign it, the new lease at a new rental amount, then say no problem, leave. Because then they've only been there 6 months, so you're not under any kind of rent control whatsoever, even if you didn't have the exemption in the lease. So just say either sign this or I expect you to move at the end of March. That's the easiest way to handle it.
Okay, second question. I was listening to an AAOA USA session with a San Francisco lawyer
Mhm.
who said that you can't add any addenda to the lease like the owner move-in exemption if it wasn't in the previous lease. Is that true?
I would disagree with that. If the tenant signs a new lease that has that exemption language in it, then you're fine. I don't see any problem with that.
Yeah, that's what I thought. Thanks a lot, Dennis.
Okay, Janice, stay warm. And we are moving on to Mehdi. How are you?
Hi, Dennis. Good, good. How about you?
I'm doing good, thank you. Always
So,
fun doing these broadcasts.
sharing your knowledge with us. I have two questions regarding new eviction moratorium. The first one, does it mean landlords cannot take any action if tenants don't pay rent? And the second
We
one,
do one question at a time, young sir. When you say this eviction moratorium, what city are you talking about?
City of LA.
Okay, so if this under this crazy new law that the city instituted, that if in fact, or actually it's the county instituted, but it does affect all cities. If the tenant self-certifies that he was a victim of the fire, he's lost 10% of his income, he's applied for wildfire relief. If that's the case, then technically you can't bring, and he has to do that to you by the 7th of each month. If he does do that, then you'll have an issue with evicting the tenant for non-payment of rent for that period from February 1st through July 31st. But if he
Okay,
doesn't do that, then there's no harm. You can certainly bring forth an eviction.
okay. You said they have to
They have to They
sell.
have to give you in writing within 7 days that they're impacted by the fire, that they've lost 10% of their income, that they've applied for the wildlife or wildfire protection. So there's this test that they have to go through. You can't ask them for proof, but they have to tell you in writing, and they got 7 days to do it, and they have to do it each month.
Okay, my second question is exactly this one. I just want to know if they have to inform me or someone else. They have to inform me.
Yes, they do have to inform you within 7 days of each month.
Thank you so much for
All
appreciate
right,
it.
you take care, sir. Hey, Sam, how are you today?
There we go. Can you hear me?
Now we
Yes.
can.
Okay, cool. Okay, so question. Um, for lease up, initial lease ups and addenda, um, DocuSign or electronic signatures or e-signatures or wet signatures, which is your choice and why? Which is more enforceable in court?
They're exactly the same in terms of enforceability. In
But
our office,
in practical reality, in
well,
terms of
our office, for example, we have it where we send everything for clients to sign by DocuSign because it's just easier to do so. Our system is such that we don't have to even go to the DocuSign website. It just comes straight from our system automatically and it'll be in a DocuSign format. So it's easier for documents to get signed and come back to our office. But again, in terms of the legality, whether it's DocuSign or a wet signature, as it's called, they're equally the same in a court of law.
okay, okay. What if one party denies that this their signature and how do you?
Well, the issue is that DocuSign goes to an email address, and that email address is your email. So it's
Okay.
not like there's two people with the same email address because that couldn't be.
Okay, cool. Thank you. Have a good weekend.
Same to you, sir. Well, actually, you know what? I'll let you know soon when that Laker game is over today. Hopefully, we'll be victorious on that. In any event, Tony C., how are you?
Thank you, Dennis, for taking my uh,
It's not really a
call.
call, is it? Well, I don't know what we
You
call
know,
this.
right now I'm driving, so I cannot put my camera on. But I just wanna thank your office. I just finished my first rodeo with your firm and went very well. I just wanna say thank you publicly. And Dennis, wherever I go, I see these new buildings being, so much construction going on, and it looks like all these laws that doesn't apply to these new constructions. What we can do as a owners of buildings that are like 20 years or older to protect against all this war that is going against us.
I don't think you can if your property is in, for example, the city of Los Angeles. New construction now is still immediately under the Just Cause Ordinance. You're going to have to register the units. You're going to have to pay the fee of $31.05 for this. Even in the unincorporated areas of LA County, you need good cause to evict, even for a single family residence. So The tide against income property owners, specifically residential income property owners, is insane in the state of California, and why I've stated that I will not be investing any further in the state of California. I have obviously a nice real estate portfolio that I'm not going to sell, since I never sell anything, but I certainly wouldn't continue to invest in this state.
All right. That was my question. Thank you.
Thank you. Good question. Maybe when there's a change in the governments and people finally wake up and understand that, number one, income housing providers or housing providers are such a valuable asset, and what you do is instead of fostering housing, what you do is you make it much more difficult by these insane rent control laws and eviction control laws, and to obtain permits, that you're just chasing people out of the state, which means that you're going to, or investors out of the state, which means that you're not going to have any housing providers, which means what's going to happen, ladies and gentlemen, supply and demand, the rents are going to go up. Stella, how are you today on a Saturday?
Dennis, thank you very much for your educational session.
My pleasure.
Okay, this case is a single family home in city of LA. I had a marshal lockout on March 3rd. And during the time, the marshal told both of us, the tenant and myself, they have 14 days to make an appointment, one-time appointment, to move their stuff. Of course, the evicted people are not happy. So after the marshal left, they were still there arguing with me. So pretty soon my realtor arrived. My realtor gave them the notice. It's similar to your notice on your website. And the realtor gave them the notice of the personal abandoned personal property notice. And she didn't leave, but she took a copy, and the realtor posted another copy on my door. And I read the content. I was a little surprised. Instead of 14 days, like the marshal said, he put down 18 days. And he checked the box of over $700 subject to public auction. But when Marshall was there, Marshall said, these junks doesn't warrant an auction.
Okay, well, let me correct you on a few things. Number one, the sheriff was wrong and your realtor was wrong. Everybody was wrong. First of all, it's 15 days from the date of the lockout that the tenant has to make an appointment to get his stuff. It's a one-time thing. If it's a full household full of furniture, probably you'd give him an 8-hour window to get his stuff. You don't have to just allow him to come in, to get a couple of items. He's got to come with a truck to pick up everything. He's got 15 days from the lockout. The form, which I have on my website, which is abandonment of personal property, that form is only used when you don't have a sheriff lockout. If you don't have a sheriff lockout, then you mail that form, and it is 18 days. Now, I would definitely rip that notice off, because you don't want to show that the stuff is worth $700 or more, because if it is, then you have to hold a public auction. We do have some referrals for that. But if the sheriff thinks it's less than 700 and you think it's less than 700, take pictures. And after 15 days, you can just toss the stuff away.
Thank you. Another question is on their abandoned vehicle. There are 3 abandoned vehicles on my driveway, which make me cannot park on my driveway. But are they considered their personal property? Can I call someone?
Well, yeah, you can call right now to pick those up, and then because you're allowed to take all of their personal property and put it to another location. And as long as you're safeguarding it, the tenant also has to pay for the storage and moving costs. So you can immediately move those cars. They're not like they're going to get sold or anything. They're going to be held by, in an auction lot or in a tow truck lot. And the tenant can pick up his stuff from there after he pays, obviously, bunches of fees. So you can do that right now.
Okay, thank you very much.
You're very welcome, Stella. Okay, we're moving along. A lot of people with questions today. Gid, how are you? Gid Martin.
Hey, how are you doing, Dennis? Long
Going
time.
good, sir.
First of all, thank you for some help. I was able to successfully evict a tenant, and my question is about that. It's a condo. It's been vacant now for probably 4 or 5 months. I had it in escrow. It fell out. I got it in escrow again. Um, if it doesn't go through, I would like to go ahead and put it back on the rental market. I would like to get the highest rent available. But I'm hearing, or in the past I've heard that you still can only go up from what the previous rent was, whatever is available, like 3%, 4%, which is crazy. But the outer exterior has been completely repainted.
You don't have to go any further, sir.
Okay.
Your understanding is incorrect in a good way, in that since this is a condo or a townhouse, there is no rent limitations. So if you want to put it back on the market, whatever fair market value is, you're allowed to charge that. Nobody can say anything to the contrary.
Beautiful. Now, when I had it rented out, I was subject to the rent increase that was available each year for
No,
some
and
reason.
that again is not true. There are no rent limitations for condominiums, townhouses, or single-family residence. That's under the Costa-Hawkins Rental Act. And under that statute, it says specifically there are no limitations. Now, the only thing would be potentially that the governor declared a state of emergency for the county of Los Angeles, which extends through July, that if you go above 10%, it could be considered rent gouging. I still think that Costa Hawkins would trump that, but I wouldn't, if you had an existing tenant until July, I wouldn't raise it above 10%. But when July comes, raise it to whatever you like. Or if you're putting it on the market right now, put it up for the market value of that unit and have a lot of confidence in doing that.
Got you. Last thing, I will be going to New York in 2 weeks, and I know somebody on the call is from New York. I'm hoping I don't freeze to death, but we'll see what the Lakers do today.
I hope they win. I think the rest of the NBA will take notice. This would be our 9th win in a row, and all I can say is I want to give my sincere thanks to the Dallas Mavericks for that wonderful trade.
What a gift. Okay.
You got that one. Okay, thank you very much. And we are going to move on to Ricky R. How are you? Got to unmute yourself, sir. I don't think you're unmuted. Let me try again. Please unmute yourself. There you go.
How are you? Okay. Well, thank you. I have a single family house in Palmdale. Last year, for 3 months, I did a major rehab and remodel to the tune of $30,000 plus supplies. And I used a handyman. He obviously was not a licensed contractor. And I found out, I just went to my tax guy this week, and he said that a Senate bill was passed last year that says that, because I wanted to, just issue them a 1099 or W-2 or something, that there's something about if this is done wrong, like if, I don't know if you have to use a licensed contractor, but the penalty is like $5,000 per check written to the guy. I wrote him like 11 checks. It's $55,000 if I don't do something right. And
Let me stop you
Yeah.
here. My expertise, young sir, is that in the landlord-tenant field. This is more of a construction / accounting problem, so I really don't feel comfortable.
No, you're
answering that
right. I
one.
thought maybe you had heard about this. There's a
No, I
Senate
have not.
bill. Okay, well, thank you, Dennis.
Okay. Moving on to Rosanna. How are you?
Can you hear
Rosanna,
me now?
there you go.
Yes.
Hello.
Oh, great one. Thank you for taking my call, my question. Like you, I am an attorney, but I'm a lot smaller scale. I do appearances for a what they call unlawful detainer assistant when they need appearances.
Well, let me stop you here. We're desperately looking for trial attorneys. If you have any interest, we're located in Burbank, but we go to all the courts. If you have any interest, we'd love that. You've got experience in unlawful detainer trials. We'd love to hire you. So send me a resume.
I will do so. I will do so. In what locations do you have need?
Well, we handle generally the court assignments. I don't know if the audience is interested in this, but we have the 29 attorneys and about 9 trial attorneys, and the court assignments are meted out basically where you live. What area do you live in?
Northern San Diego County, and my preference is San Diego, Riverside, or I've
Yeah,
gone
no,
as far as
you'd be
Barstow.
too far away from us, unfortunately. We need you
Okay,
to
well,
be
if
in
you
LA
have
County.
anything in this area, I'll send it. But LA County is just not economical for the clientele.
Yes, no, I understand that. In any event, what's your question?
And my question is here, and I've been doing this for a number of years, but I had never heard of this motion to require a tenant to deposit rent into escrow pending a trial. But we've got one where the tenant believes that she is an owner in some way and has filed another action to claim ownership. So it's gummed up the works with regards to our unlawful detainer action. And the attorney handling the other case says, well, why don't you file a motion requiring the tenant to deposit this rent into escrow? This is the San Bernardino case. And I've been doing some research on this and trying to find the right forms and the right way to do this because I had never heard of this before. So
Yeah,
please
this law's been on the books for
tell me
many
how it
years.
works. Yes.
We did many years ago try to institute that, and the judges just aren't buying it. So it's a futile act to try to get the tenant to post the money with the court. And also, if the tenant doesn't have the money to post with the court, there's no basis upon which they're going to strike their answer so that the case goes by way of default. So it's an act of futility.
Okay. But assuming that my client and the other attorney on the other case insist on this, what would be a reasonable fee to charge for this?
That's up to you
I've got to go
what
start
your
looking it
hourly
up.
rate is. But when you say stuff like that, I always say to my clients that, look, I'm the doctor and the patient doesn't tell me which way to cut. Okay, that's the doctor determines which way to cut the patient. And if your client is demanding that you file a motion, but you know that the motion is not going to be accepted by the court, then I would decline the assignment, quite frankly. But in any event,
Okay.
thank you very much. We are going to
Thank you.
move on to Ro. How are you?
Hi.
Hello.
Hi. Yes, I have a question about the Just Cause Ordinance and registering.
Yes.
Does that also include for commercial property?
Good question. This is only for residential property only and in the city of Los Angeles.
Okay. And my second question is, when renting out a house, now you're supposed to put a posting that stays on the property, telling them their rights.
Yep.
Who the
That form is on my website at evict.
Yeah, but
.com.
I have the form and it's really big. I mean, a tenant is going to leave a huge form like that on their door, or it just doesn't seem to make a lot of sense.
So what you're saying is that your representatives on the city council and the mayor for Los Angeles are out of their minds. That's what you're saying, because that's what they require.
Yeah. Okay.
So, and I always use the example that you rent out a house in Brentwood for $55,000 a month to a CEO of some software company. You shake the hands, he pays you the rent, and as you walk out, right on the front door, you post that notice. See
Right.
how that tenant's going to like that.
Yeah. So just post it and then.
And let them rip it down.
Okay. Thank you so much.
Okay, Ro, thank you. Okay, let's see what time. We're gonna take maybe one more. David Khosravi, how are you?
Doing great, Dennis. Thank you for this seminars that you're having. Quick question. This just you were talking to this previous person. Is that for single homes or apartments or what?
If we're talking about posting these notices, it's for every residential unit in the city of Los Angeles. If your property is under RSO, then there's 2 forms to post. If your property is under JCO, the Just Cause Ordinance, then it's only 1. Both of those forms are on my website at evict123.com, and it's in the free form section.
Got it. So the question I had was earlier, you mentioned the beginning that you said that some of the homes are getting those notices, especially the ones that the addresses are different
That the
than.
mailing address is different than the property address, correct?
So I guess the question would be, what about those that are not different and they don't get it, and yet they're living in there? Are they going to get fined?
Well, the issue is that you have to receive a statement. If they don't send you a statement, then you can't pay it. Even now, if you get this letter, you still haven't received your statement. To register, you have to have the statement number. So it's just a big boondoggle. So I had one client call the city because he didn't understand that he didn't have a registration number, a statement number, but yet he got this and he wanted to register and he wanted to pay. But of course he couldn't. So he calls the city. I kid you not. When he was on hold, they tell you how many callers are on hold before you. He was ready, the 540th caller in line waiting, and I can guarantee you he wasn't getting to be talked to that day. Anyway, thank you very much, David. We are at the end of the hour. Thank you for participating either in YouTube or in the Zoom room. You know, we'll be doing this next week on Saturday. For those people watching this on the YouTube video, please, if you'd be so kind as to like the video and subscribe to my channel. And with that, I hope a great Laker win today against the reigning champs, the Boston Celtics. Anyway, take care, everybody.